Module 4. The Ontario Human Rights Code. The Ontario Human Rights Code and the AODA work together in various ways to promote equality and accessibility. The code's goal is to provide equal rights and to create a climate of respect where everyone feels part of the community and can contribute fully. Additionally, the code says people with disabilities must be free from discrimination where they work, live, and receive services, and their needs must be accommodated. It's important to note that the code has primacy. This means that Ontario laws, with a few exceptions, have to follow the code. So, if there is a conflict, the code overrides the AODA and other provincial laws. Ultimately, the law offering the higher level of accessibility comes first. However, the AODA standards don't limit or replace the requirements of the code or any other law. Additionally, meeting AODA standards doesn't guarantee that an organization has met code requirements or that the organization won't receive human rights complaints, but it may lower the risk of complaints. While the code and the AODA work together, they have some important differences. Under the code, when a person with a disability needs accommodation, there is a duty to accommodate. This means organizations may need to provide an individualized response to an accommodation request. Additionally, the code applies to all Ontario organizations regardless of type and size. In comparison, the AODA sets accessibility standards that organizations must meet. These standards apply to all organizations with one or more employees in Ontario. However, requirements vary depending on an organization's type and size. More specifically, the code offers protection of rights, equal opportunity, and freedom from discrimination. It applies to jobs and services and states that employers and service providers must accommodate people with disabilities to the point of undue hardship. Employers must accommodate employees when they cannot perform all of the duties of the job because of their disabilities. Accommodation means not denying people jobs or services in the first place if they can be accommodated to the point of undue hardship. The code protects people from discrimination and harassment because of past, present, or perceived disabilities. It is recommended that organizations try to identify and remove barriers before problems arise instead of waiting to answer individual accommodation requests or complaint. Importantly, the code is not meant to punish. Instead, the code promotes educating and working with organizations to make changes that prevent discrimination and harassment. If discrimination does happen, the goal is to fix the situation and provide equal opportunity for the person with a disability. Accommodating the individual needs of people with disabilities is a legal duty under the code. This allows people to benefit equally and take part fully in the workplace. Under the code, the most appropriate accommodation is the one that best meets the individual needs of the person with a disability. Employers are only exempt of this duty if it would cause undue hardship, a very high test. While there is no set formula for accommodation, you must consider individual needs each time a person asks to be accommodated. Many accommodations can be made easily and inexpensively, but if it's not possible to put the best solution in place, or if doing so results in undue hardship, you still have the duty to take the next best steps. Examples of accommodation include providing printed material in alternative formats such as electronic files, large print, or braille, providing sign language interpreters or real-time captioning for people who are deaf or hard of hearing, offering flexible work hours or break times, modifying job duties, retraining, or offering alternative work, installing automatic door openers and accessible washrooms. Undue hardship is the legal limit of the duty to accommodate. It refers to situations where severe negative effects would outweigh the benefits of providing accommodation. 3 factors are used to determine undue hardship. 1. Cost. For example, if a small business cannot afford making accommodations without reducing staff or hours. 2. External funding sources. Are there grants or tax breaks available that could reduce accommodation cost? 3. Health and safety considerations. If an accommodation violates occupational health and safety regulations, need to keep all workers safe while meeting accommodation needs. The court has set high standards of proof. There needs to be clear evidence of undue hardship to waive the duty to accommodate. What to do if you need accommodations. Tell your employer, union, landlord, or service provider about any needs related to your disability and your job duties, tenancy, or the services being provided. Provide supporting information about your disability-related needs, including medical or other expert opinions where required, and get involved in seeking accommodation solutions to the best of your ability. In response to requests for accommodation, employers and services must accept requests for accommodation in good faith. Act promptly, even if it means creating a temporary solution before a long-term one can be put in place. Cover the costs of accommodations. Ask only for information needed to provide the accommodation. For example, you may need to know that someone with vision loss is unable to read printed material, but not how or why she lost her vision, and respect the dignity and privacy of the person asking for accommodation. Make sure the accommodation process doesn't lead to reprisals against that person. The code is enforced by the Human Rights Tribunal. They hear discrimination claims on any code ground. This includes claims from individuals who believe an organization or a person has failed to accommodate disability-related needs. Additionally, if an accommodation was not made and would not have caused undue hardship, a claim of discrimination can be made to the Human Rights Tribunal of Ontario. The Human Rights Legal Support Centre helps people through the human rights process, such as completing an application or claims to the tribunal. Individuals cannot file accessibility complaints under the AODA, but in cases of non-compliance, the Directorate can enforce standards through mechanisms set under the law. This concludes the training on the Accessibility for Ontarians with Disabilities Act. After completing this training, you should know what the AODA is and its purpose, the meaning of disabilities and barriers, the accessibility standards you must support, and how to support them. Service tips for serving people with a variety of disabilities. What the Ontario Human Rights Code is. To complete the knowledge check, please click on the course overview button in the top right corner of your page, and then click on the quiz.